Good morning, Santa Clarita. You are listening to your hometown station, AM 1220. I am attorney Wade Skalsky, and this is Wade Beyond The Courtroom. Today, we're going to learn if an attorney can put someone on the stand that they know is not going to tell the truth. But before we get to that, Mike is on the board. Mike, how are you today?
Doing well, Wade. How are you?
I'm doing well. You're back into the flow of the cage matches. You win the weekly contest to be the board operator, and people have stopped challenging you now.
Exactly.
It's time that your dominance has been established.
I think I've, kind of earned this spot now.
Good. Yeah. Now, how was your last week? Anything good going on? Anything exciting?
No, everything just status quo. Things are good.
As we always say in the show, sometimes relaxing weeks are good because excitement it creates challenges sometimes. So let's do a little bit of Wade's Week in Retrospect. This is something that we'd like to talk about. So I'm in court this week. Again, I'm not going to give you the specific court that I'm in, right? But it's a criminal court. There's all sorts of cases being heard. The calendar's pretty heavy. There's maybe 30 or 40 cases on the docket that day.
Right.
And what a docket is, if you don't know that, is just basically it's a fancy word for list of cases that are going to be heard that day.
I thought it was pocket spelled wrong.
Right, exactly. Yeah. Or there's some sort of word game in there. We can probably figure it out. Is it like
a vanilla folder or manila folder?
Yes, or deer or deer.
Yeah,
yes,
right.
Exactly.
Go ahead.
So I'm sitting there and I'm out and I'm talking to my client in the hall and kind of we've already prepared. We know what's going to happen. It's going to be a short hearing. And there's another lawyer and a client that's out in the hallway. And what people may not know, the sort of day-to-day workings of the court, is that everyone thinks that perhaps all of these conversations are taking place in an interview room that is quiet, and a lawyer and his client are talking about very confidential things in that place. And that does happen. There are courts with interview rooms, but some courts weren't really designed, I don't think, with the day-to-day workings of how the courtroom itself goes forward. And so you'll have situations where you'll have lawyers and clients having what's called a privileged conversation, all in the hall within earshot of each other, and everybody just pretends they can't hear anything.
Right.
Okay? And so I'm not going to get into the specifics conversation that this lawyer was having with his client about what they were saying, because that would be unprofessional. Sure. However, it was interesting because they were sitting right next to us and we were done and they were done. And I could hear them talking and I could hear the client talking. And the reason why this is important is because we go into the courtroom and this client is taking a plea agreement. And so we're sitting and we're waiting to go, and they stand up. And the judge calls the case, and they start going, and then the judge starts asking the client questions. And an interesting thing happened, Mike. The client suddenly had a British accent.
Oh.
Now, it took me aback a little bit, because when I heard this person talking in the hallway, they were as American as you and me. There was no British accent, there was no issue or whatever. And so it was funny because I'm sitting there and I'm like, well, this isn't a case of perjury, because the person's whatever they're speaking is the content of what they're saying.
And it wasn't Hugh Laurie, right?
That's right. No, it was not. Okay, no. And I'm this person, what they were speaking was true, So, but the way they were delivering the information was in a British accent. And it just made me kind of laugh because, unless someone, and people also don't know this about when you're taking the record down for the court reporter, is that the court reporter obviously just types what is said.
Right.
So if you wanted to make a point on the record to come back later, you'd actually have to say, let the record reflect that this person is speaking in an English accent.
Gotcha.
And that brings us around to what we're going to talk about today was that specific situation an ethical problem? And I don't think it is. I think that person, I don't think they were having fun with the situation, because what they were involved with was not fun at all. But I think people deal with stress in unusual ways sometimes.
Yes.
And so maybe that person was using that as a coping mechanism, but I've never seen anything like that in 17 years. And so I'm sitting there and I'm like, okay, that was interesting. But typically what we're going to talk a little bit about today is, as an attorney, let's say that you have a client who's going to testify in a hearing or testify at a jury trial, and that they plan to say something that's not true.
Right.
All right. Now, you're a lay person. You're not an attorney. What is your perception, if you will, of how often that happens, or does it happen at all, from either movies or TV? Do you have an opinion on that, Mike?
I think it happens probably a lot.
Okay.
We probably don't recognize it.
Right. Well, I mean, I think that there's a situation where everyone says, okay, well, there are people obviously who don't tell the truth and all of that. But as an attorney, you're in a very you're in a very tough situation because you're not what's called an officer of the court. Have you ever heard that term before?
Yes.
All right. So an officer of the court basically is that you're held to a certain standard as a member of the bar.
Sure.
All right. And as an officer of the court, you're supposed to make sure that the court runs well, that there's no shenanigans. You're supposed to have decorum. You're supposed to wear a suit. You have some obligations. Now, those obligations, they don't necessarily they can conflict with your obligations of representing your client. And in almost all cases, obviously, your representing your client takes precedent. All right, but this is an ethical situation to where it's very interesting because your client may, the truth of what happened may not really assist your client very much in their case. Okay, and that is why one of the great parts of our system is that no one can be forced to testify. So basically, the easiest solution in that situation is that when your client's going to want to has some story that just sounds crazy. They were at NASA ready to be launched to Mars as an alibi or something. You really don't want to have to, go down that road because obviously that's not going to be helpful for anyone. But when we come back, we're gonna talk a little bit about what happens when you actually have a real dilemma, which is your client really wants to take the stand in that situation. You're listening to Santa Clarita's hometown station, AM 1220 KHTS. I am attorney Wade Skalsky, and this is Wade Beyond the Courtroom. Welcome back, Santa Clarita. You're listening to your hometown station, AM 1220 KHTS. I am attorney Wade Skalsky, and this is Wade Beyond the Courtroom. So, Mike, during the break, I asked you, who is Hugh Laurie? And then you told me.
Remember the show House?
Yes, I do, yes.
Dr. House.
Yes, and it was interesting because I think you asked me that because of the issue that he has an accent in real life.
On the show, he does not.
Well, I guess to him, he doesn't have an accent. He's like, I speak Queen's English, and you people speak with an accent.
When he's not doing that show, which, of course, House is off the air, but he does have a British accent, pretty much so.
My wife and I watch The Walking Dead, and there's an actor that plays the main character on that, Rick Grimes, by the name of Andrew Lincoln, and he is English, and he has a perfect American accent for 6 years or whatever. And I'm always impressed by actors and actresses that can affect an accent, over time. Not like did you ever see Kevin Costner's Robin Hood?
I think I missed that.
I saw the movie a couple times. It's an old movie. It was back in 91 or whatever.
Any good?
I enjoyed it. I saw it a couple times, but what was not good in that movie
was his voice.
Kevin Costner's accent. So sometimes he had an accent, sometimes he didn't. Sometimes he sounded Jamaican. Oh no, wait, that's me when I try to do accents. Yes, that's the only accent I can. Every accent I do devolves into Jamaican for some reason. But
fun times.
But anyway, so the reason why obviously we're talking about that is the issue of the person suddenly having an accent in court, and then what happens if someone tries to sort of take the stand and say an untruth. So. I would agree with you, Mike, that this does happen in the justice system. Obviously, people are under a lot of pressure. There are big hammers for them in terms of if they're to lose their trial or their hearing, and there's a huge incentive for people in that situation, obviously, to not tell the truth.
It becomes an ethical issue as well.
Absolutely. We actually have, as lawyers, I took a very good ethical refresher course. We have continuing legal education a few weeks ago over here at the I think it's the TPC, and yes, and we have to keep up with that. Now, the bar of California has an attorney hotline, which is, I don't know if people know this, but they have an ethics hotline. So if we get into a situation that we're unclear of what we should do, you can anonymously call that hotline for the state bar, and then they'll call you. It's a really weird system. I don't know why they do it that way. You call them, and then you leave them a message or whatever, and then they call you back within 2 days or something. I don't know. I don't think that overloaded, but the way they do it is a little weird. But anyways, and then typically what they'll do, though, is they're almost like lawyers in that way that they don't give you a straight answer. It's always, they'll point you to this opinion or whatever, and they kind of point you in the right direction. They kind of leave it to you to figure it out. But it is helpful, and if you're totally clueless about what am I going to do in this scenario. So anyway, in this situation, though, there is a lot of established case law in terms of what you can and cannot do. So number one, the simple answer is, Wade, can you put a client on the stand that you know is not going to tell the truth? And the answer to that is no. All right. As an attorney, you cannot do what's called suborn perjury, meaning you cannot assist someone in telling a lie to the court.
Now, do you think there are attorneys out there that do that, though?
Well, look, I can either confirm or
I'm not saying throw anybody under the bus,
out there. But look, there's I don't know, there's 220,000 people that are barred, or 250,000 people that have been barred in California since the beginning of the bar. So I'm fairly certain that some of them do that.
Yeah.
But I think most of the time that most attorneys, they try to get it right. They try to do the right thing. And for a couple of reasons. One is there's the ethical issue of what do I do in this situation? I don't want to, I want to be an ethical attorney. But then two, typically your client, from a sort of a selfish perspective for your client, they're not the most skilled people in the world at testifying because they've never done it before.
Right.
And remember, too, is they have an extremely skilled prosecutor that's going to be asking them questions on what's called cross-examination that has limitless funds and investigators, as many as they want, experts, as many as they want. So anything that you say, they're going to be able to attack with giant amounts of resources. So unless your story that you're going to construct is perfect, you're going to have some issues big time. I mean, when I was a prosecutor, almost always, whenever I heard the words that a defense attorney was putting his client on the stand, I was like, we're going to win. Because in that situation, it's just, I know more about the case almost always as a prosecutor than a defendant does, just because the defendant knows the case from his perspective, but I have all of the, there are things always that I know that he may not know. Do you know what I'm saying? So I have other witnesses or whatever, and it doesn't really matter in that situation. They're not consistent either, So, I mean, obviously, the defendant knows whatever happened, because he was there when it happened. But in terms of other things that he may draw in for their story, those things as a prosecutor you can attack because you have a lot of resources in that way. Now, as a defense attorney, there are some avenues for you that you can do. And the first step that you would do is that when you were speaking to your client in a situation like that, is you would try to tell this to them. You'd be like, look, I understand that you don't, number one, the first thing you try to do is be like, look, it's not in your best interest to testify. Rarely do people put their clients on the stand. Actually, it doesn't happen very often. And when it does, you see it in high profile cases. The Aaron Hernandez case, did you see that case?
Yeah.
Anything about that where he was just found guilty, right? That they didn't put him on the stand. And so there's a lot of situations where you don't even have to deal with that because there's no way we're putting you on the stand. They don't want to take the stand, and you're good. Right. But in the situation where you're faced with as an attorney, there is guidance as to what to do in that scenario. And step number one is you sort of start to explain these things to your client. And you're like, look, this prosecutor is very skilled. And secondly, usually their story makes no sense. Do you know what I mean? So you're like, your story is not really making any sense for these reasons. And in that way, you almost act as a prosecutor to show them what the prosecutor is going to do. I kind of put my prosecutor hat on. If I've ever had a client that's wanted to do that, and I'm not saying that I have or have not, but if I did, what I would do is I would put my prosecutor hat on from when I was a prosecutor, and I would cross-examine them, and that usually does the trick.
Gotcha.
But when we come back from the break, we're going to talk about some other things that attorneys may be able to do in that situation. You're listening to Santa Clarita's hometown station, AM 1220. Welcome back, Santa Clarita. You're listening to your hometown station, AM 1220 KHTS. I am attorney Wade Skalsky, and this is Wade Beyond the Courtroom. So we've been talking a little bit about what happens when an attorney's client decides they want to take the stand and say something that's not true. What does that do in terms of a moral quandary for the attorney? So we've been talking a little bit about, number one, the best way to handle that really is before you ever get to trial. So it can get exciting, however, when you and your client are on the same page for the months leading up to trial. And in the middle of a 4-day trial, your client looks at you and says, you know what, Wade, I've changed my mind. I think I want to testify today. And so that's always an exciting experience. So let's just say in general, let's take me out of it, but let's say that an attorney experiences that. What can that attorney do in that scenario? He's tried to dissuade the person from testifying. He knows the person's going to take the stand and say something that's not necessarily true. And he cannot convince him over the break to change his mind, right? Well, the other two things an attorney can do, and this is a really kind of an amusing thing for me to talk about, because this is where the sort of the theory of law butts up against the practice of law and really what happens, because the rules say, well, number one, you can try to withdraw. Right? So, because you have to say to the judge, well, listen, I can't tell you why I want to withdraw, because you don't want to throw your client under the bus.
Sure.
But you have to sort of basically say that I need to withdraw. You have to sort of imply why, but not say why. And number one is I've never seen an attorney do it, and I've never even heard of an attorney doing that.
If a judge knows that a client wants to testify and you're advising them not to, can the judge make a ruling on that?
Well, let me put it this way. A person has the right to testify in their own defense.
Okay.
And so a judge, everyone will start to admonish everyone. It will be, the attorney will put on the record, I'm advising my client not to testify. Now, I see that all the time. Like, off the record, the attorney then will say, okay, well, I'm going to put on the record, I'm advising my client not to testify in this case. And the attorney is really doing that for two reasons. One, he's hoping that the client will realize, because he's making a big to-do about it and saying, I'm putting this on the record, I have told him not to testify or advised him not to testify, then the guy might change his mind. The judge then tries to change the guy's mind basically by saying, hey, listen, you might want to listen to your attorney. And this is a really funny little sort of anecdotal thing that people don't realize. So judges will then, suddenly you're the best attorney in the world, because a judge doesn't want to have a situation occur either. So he'll start to talk up your attorney, where he'll be, okay, your attorney is incredibly skilled, he's doing a great job for you, you might want to listen to him. And that's the only time a judge will ever pump up an attorney on the record like that, is when he's basically trying to help the attorney out. Even if he thinks it's the worst attorney in the world, he knows that he doesn't want this guy. The attorney's trying to tell this guy not to testify. He's trying to actually help the client to listen to his attorney. So it always makes me laugh when judges do that, because even the really curmudgeon ones do that on occasion, because they don't want that type of thing to go forward in their courtroom.
Exactly.
So the attorney can try to withdraw, and then there's some issues too where I guess there's situations where the attorney could try to alert the judge, but the whole problem there is that there's something that's called attorney-client privilege. And so what attorney-client privilege is that any communication that you have with your client is confidential. So
Exactly.
The client has to be able to understand, look, I have to be okay that whatever I tell my attorney he's not going to go tell somebody else, because obviously, he could go to the police, he could go to the judge or whatever. So these ethical rules and that obligation, they butt up against each other. A similar situation occurs with therapists sometimes, where a therapist or a psychiatrist will be helping someone, and then the person says something, well, I'm going to hurt myself or I'm going to hurt someone else. Then the psychiatrist is in a situation to where they have to make a decision. Oh, okay, do I notify the authorities? Is this person just saying it, or do they mean it? And then they've got to make a judgment call. Attorneys have to do that as well. If someone comes to me and says, I'm going to go commit a crime, or I'm going to go hurt someone or something like that, then we have to make a judgment call. Is this a real threat? Is it not a real threat? And I've actually had to make a couple of those calls in my career, not very many times, maybe a couple times over 17 years. And thankfully I've been right every time. So, but that's a very stressful situation to be in. And, that's what is so fascinating about sort of the theory of law and how it actually plays out in court. And then in these situations, making those decisions, there's really is sort of a middle ground, sort of a gray area that is difficult to navigate. But you do have resources. I have mentors that I go to and that have been through it many times, or between 5 lawyers, they all know this is what we do. There's the California State Bar Attorney Hotline. But with the question that we're talking about today, I've never really had an issue with that in terms of putting a client on the stand, simply because I do a lot of prep work with my clients and I make sure they understand.
Yeah, I mean, the grooming that's involved, it's got to be atrocious.
Yeah, well, yeah. I mean, if you're going to go to trial, and especially look, you prep your client. What will happen if they testify? You may do some mock trial issues to where you put them on the stand. You'll get another lawyer to help you. Like, you have another lawyer who's really, really good. I did that a couple times as a defense attorney, where there was a high-profile case that my friend was doing, and he said, hey, listen, can you come in and can you act like a prosecutor? And I said, well, since I was a prosecutor for a number of years, yeah, that won't be a problem. So he brought me in, and we did a mock trial, and after that mock trial, his client decided that it wasn't in his best interest to testify. So there are basically, you can avoid a lot of those problems by doing your due diligence, by doing a lot of work, because at the end of the day, my job as an attorney is to put my client in the best position possible.
Right.
And I don't want them to put themselves in a situation that will make matters worse. And that is something that is a job for me, is to communicate to them, hey, look, this may seem like a good idea to you because everything that you've seen in the movies or you've watched on TV, like, you want to sort of play professional witness now.
Sure.
But you need to understand what you're up against. You need to understand the strengths and weaknesses of your case. And in those scenarios, that's my job as an attorney. And I've been very lucky in terms of I've never had to really deal with sort of these issues that we've been talking about today. So I hope this was interesting something for you today, Mike. I hope you learned something exciting.
I did.
Basically, what you did learn is when you get nervous in the studio, you can affect a British accent and you might feel better.
Oh, really?
Oh, nice. All right, great. Well, listen, I really appreciate the conversation today, Mike. Good to see you back on the board.
You as well. Thank you.
We'll see you next week. And you've been listening to Santa Clarita's hometown station, AM 1220, KHTS. I am attorney Wade Skalsky. This is Wade Beyond the Courtroom. Stay safe, Santa Clarita, and we will talk soon.